in live stream. It's on live stream YouTube. It's battery, social battery. Battery. 73%. My last 3 hours. Just only the criminal. It's only the criminal that prison. Criminal person. Persons, other substance.
Appearances.
Good morning, my lord.
Appearances.
My name is Caleb Joseph. Caleb Joseph, my lord, for the defendants. Sorry, I had to announce my appearance.
Yes, if the claimant is not online or is not appearing. Claimant counsel. Temitokwe. Temitokwe. Okay, this matter is for judgment. Hello?
My lord?
Caleb.
Yes, my lord, I can hear you.
You should be responding so that I know that we are still together, isn't it?
Okay, my lord. Thank you, sir.
Oh, you are not seeing me?
I can see you. I can see you.
Okay, thank you. This is the judgment of the court. Something I just told him now that he should be responding. Let's know we are together. Caleb. Caleb.
Okay, sorry, my lord, there was a break.
Please be responding when the court talks. You respond so that we know we are together. I said this is the judgment of the court.
As a court basis.
That is how to do it.
Yes, sir. As a court basis. My lord, we are ready, sir.
Thank you. By an originating summons taken out on the 12th January 2022, the claimant seek for the determination of the following questions. 1, whether by section 4, subparagraph I to H of the third schedule to the Federal Universities of Technology Act, and by virtue of the letter of appointment of the first claimant dated 27th May 2021, the removal or exclusion of the, where is the file? The removal or exclusion of the name of the first claimant from the membership list of the congregation of the first defendant by the second defendant is not unlawful. 2, whether by virtue of the judgment of the National Industrial Court Akure in NICN/AK/46/2018, the exclusion of the graduate members of the second and third claimants from the membership list of the congregation of the first defendant by the second defendant is not illegal and wrongful. The claimants seek for the following reliefs. The claimants seek for the following reliefs. One, a declaration that the removal or exclusion of the first claimant's name from the membership list of the congregation of the first defendant by the second defendant is wrongful and unlawful. Two, a declaration that the action of defendants in limiting the members of third claimants who are listed for the membership of the congregation of the third defendant to administrative officers by the defendants is wrongful and unlawful. Three, an order directing the defendants to reinstate the name of the first claimant as a member of the congregation of the first defendant. Four, a mandatory order restraining the defendants, whether by themselves, their agents, or anybody, however, acting for or through them, from preventing the first claimant from participating as member of congregation under the third schedule of the Federal Universities of Technology until his tenure expires. The originating summons is supported by a 27-paragraph affidavit deposed to by the first claimant for himself and for the second and third claimants with their consent. Accompanying the summons is also a written address and 4 annexures marked as exhibits A, B, C, and D. Affidavit in support of originating summons. In a 27-paragraph affidavit in support, it is the case of the claimants that under the Federal Universities of Technology Act laws of the Federation of Nigeria, one of the major and vital organs of the first defendant and the third defendant is the congregation. That members of the second and third claimants are employees of the defendants, that under the third schedule to the Federal Universities of Technology Act, membership or composition of the congregation of the first defendant consists of, among others, every member of the administrative staff who holds a degree other than an honorary degree of any university acceptable and recognizable and recognized by the defendants. That the second and third claimants have avalanche of members who are administrative staff and who hold degrees of universities recognized for that purpose of FUTA Act, among which I am. Some members of the second and third claimants who are administrative staff have first and second degrees from recognized universities acceptable and recognized by the defendants. The defendants have continued to prevent these qualified members from participating in the congregation of the first defendant, interpreting administrative staff to mean administrative officers only, whereas administrative staff under the first defendant means persons in the employment of the first and second defendants other than academic staff who hold administrative, professional, or technical posts designed by the third defendant in the first defendant. The court in NICN/AK/46/2018 between NASU and 3 others versus Federal University of Technology, Akure, and 2 others on 9th July 2019 confirmed that all members of the second and third defendants who are degree holders are members of the congregation of the first defendant. That I am a non-teaching staff in the Department of Directorate of Academic Planning, and I hold a Bachelor of Science and Masters of Technology. A membership of the congregation has been ascertained by the decision in NICN/AK/46/28 that I have actively participated in the congregation activities from the inception of the judgment in NICN/AK/46/2018 till date. That on 27 May 2021, the congregation appointed me as its representative on the Primary School Management Board for a 2-year term. That my participation in congregation activities has been going on until 10th January 2022. that the Vice Chancellor of the Federal University of Technology, Akure, single-handedly picked some few persons contained in a list attached to a letter written by the registrar on the said date. I think that should be 10th May. That my name as an officer of the congregation for a tenure of 2 years and some members of both Nasu and Sanu were omitted from the membership of the congregation of the defendants. That the defendants have shut me out and precluded me and some other qualified members of the second and third claimants from participating in the proposed meeting of congregation. As we have been told, we cannot participate despite the fact that we are qualified. Written address in support of the originating summons. In his written address, it is a submission of Learned Ajayi Adeolu that this case simply calls for interpretation of Section 4.1, paragraph A to H of the third schedule to the Federal Universities of Technology Act, which has already been done by this court in NICN/AK/46/2018 and laid to rest. Counter affidavit of the defendants. In a 14-paragraph counter affidavit, the main and relevant depositions of the defendants are in paragraphs 9, 11, 12, and 13 to the effect that the judgment of this court in NICN/AK/46/2018 did not say that every member of congregation in Article 4.1 A to H must be presented and attending every meeting of the congregation, but that members of the first and second claimant can still, first and second claimants can still be members of the congregation, but they may be denied right to attend or audience by the exercise of the discretion of the Vice Chancellor. That although first claimant is a representative of the congregation at the management board of Futa Secondary School, that fact alone does not assure attendance or participation in all meetings of congregation. That the letter of 10 January 2022, Claimants Exhibit D, was predicated upon a letter of Nasu and SSA and Sanu, second and third claimants, dated 6 January 2022, Defendants Exhibit PP2, which claimants omitted. That in Exhibit PP2, the second and third defendants requested for a list of the members of congregation for the purpose of a meeting of congregation scheduled for 13 January 2022. The list of members of congregation attached to the letter of 10 January 2022, Claimants Exhibit D, is the list of persons, Sano and Nasu, who were appointed to attend the January 13 meeting of congregation. Written address of the defendants. In his written address, Learned Fakunle San raised two issues. The first being that the suit cannot be determined by originating summons because the depositions in the counter affidavits and the documentary evidence marked Exhibit PP1 and PP2 variously contradict the facts deposed to by the first defendant. That once the facts deposed to in the support of an originating summons are in dispute, the case cannot be determined by originating summons. That assuming the court holds that the case can be determined by an originating summons, that upon the materials presented before the court, it turns on the interpretation of Articles 4.1A to H, 4.3 and 4.4 of the third schedule of Federal University of Technology Act, which cannot be done without recourse to the facts, which facts are in dispute. The second and third claimants are not members of congregation, so they are not proper parties and their names should be struck out. The defendant's issue 2 is whether the claim of the claimants is justiciable before the court. The learned answer the question in the negative. His reason is that the question of the number of congregation who should attend is his reason is that the question of the number of congregation members who should attend a meeting of congregation of FUTA is the prerogative of the Vice Chancellor of FUTA, that the conduct of meetings and attendance of meetings of congregation is a domestic affairs of the first defendant, and the courts cannot and will not usurp the functions of the second defendant in the selection of the number of members of congregation to attend a meeting. Court's decision. In an originating summons, the issues for determination are usually questions for determination as denoted by the claimant in the originating process, and in this case, they are as follows. I reproduce them as earlier read. In an originating summons, a claimant should be bound by the questions submitted for determination, as those questions already define the perimeters and circumstances of the case. Accordingly, the issue further formulated by the claimant counsel in his written address shall be ignored. Preliminary issues. The defense counsel raised issues which are more in the nature of objections, and the court shall turn to them anon. The defense counsel argued that the second and third claimants are not members of the congregation, so they are not proper parties and their names should be struck out. This argument is misplaced and it fails because it ignores the case of the claimants, which is that members of the second and third claimants are members of the congregation, but some of the names of some of their members, including the first claimant, were omitted from the list of members of congregation in Exhibit D. The second and third claimants are entitled to sue to protect the interests of their members as sought to be done in this case. I hold that the second and third claimants are proper parties in this suit.
As copies.
That is how we go. Thank you. The defense counsel also argued that the suit cannot be determined by originating summons because the depositions in the counter affidavit and the documentary evidence marked Exhibit PP1 and PP2 variously contradict the facts deposed to by the first claimant. That once the facts deposed to in support of our originating summons are in dispute, the case cannot be determined by originating summons. It is not the law that when the depositions in the counter affidavit and the documentary evidence variously dispute the facts deposed to in the originating summons, then the suit cannot be determined by originating summons. When the depositions in the counter affidavit dispute the facts deposed to by the claimant, it means issues have been joined. Only disputed facts that must require calling of evidence for a proper resolution that renders a suit unsuitable for determination under originating summons. In this case, both parties are agreed that the suit simply calls for and turns on the interpretation of Article 4, Sub 1, paragraphs A to H, 4.3 and 4.4 of the third schedule of the Federal Universities of Technology Act. The fact is the exclusion of the name of the first claimant and other members of the second and third claimants from a list of congregation members, which is not denied but further explained. It is a proper case to be instituted and determined by an originating summons. Learned counsel did not make any attempt to point out the disputed facts, and I did not see any disputed facts. Defendants simply tell the story from a defendant's perspective and supplied extra materials. I do not see any contradiction that necessarily requires the calling of oral evidence and cross-examination. Learned counsel for the defense has also argued that the claim of the claimant is not justiciable before the court because the question of the number of members of congregation who should attend a meeting of congregation of FUTA is a prerogative of the Vice Chancellor of FUTA. That the conduct of meetings and attendance of meeting of congregation is a domestic affairs of the first defendant, and courts cannot and will not usurp the functions of the first defendant in the selection of the number of meetings of congregation to attend a meeting. To attend meetings. This argument also ignores the claim and concentrates on the defense. This suit seeks for an interpretation of Article 4 of the third schedule to the Federal Universities of Technology Act and the judgment of this court in NICN/AK/46/2018. These are justiciable matters. Furthermore, the rule of absolute non-justiciability of domestic affairs of an organization is applicable only to voluntary associations such as political parties, religious organizations, trade unions, etc. When it comes to governmental institutions, such as the defendant hearing a university, the application of this rule is highly limited. The conduct of its domestic affairs must comply with the law establishing it and the rules and regulations made for the conduct of its domestic affairs. Where an individual's constitutional rights to fair hearing are violated or where there is a glaring violation of the law or rules and regulations, the matter is justiciable. See Inua versus Banyero University, Kano, and another 2016 LPLR 4115CA, where the court held that certainly where the complaint is lack of fair hearing, the courts must jealously guard the rights of the student to his constitutional right to be heard before any onerous sanction is meted out against him. Similarly, in Olarewaju versus Unilac and others, 2014 LPLR 2409CA, the court held that conduct of examination or assessment of works of students by the universities, by the examiners have always fallen within the exclusive domestic affairs of the university. And unless there is clear evidence of glaring infractions on the rights of the student, such assessment is not open to judicial review. In the instant case, it is the case of the claimants that their rights under Article 4 of the third schedule to the Federal Universities of Technology Act and the judgment of this court in NICN/AK46/2018 has been violated. I hold that the claim is justiciable before the court. On the whole, the objection fails.
Score, please.
The objection fails and is dismissed.
Score, please.
Merits of the case. In summary, the case of the claimants is that as a member of the second and third claimants, he is qualified to be a member of the congregation of the first defendant and that his position was affirmed by the National Industrial Court in NICN AK46/2018 on 9 July 2019, and that since then he had remained and participated as a member of congregation until 10 January 2022, when a list of the members of congregation omitted his name and some members of both NASU and SANU. As rightly submitted for the defendants by the learned Silk in paragraph 4.05 of his written address upon the materials presented before the court, this case turns on the interpretation of Article 4, paragraph 1, subparagraph A to H, Article 4, sub 3, and Article 4 sub 4 of the third schedule of the Federal Universities of Technology Act. But the facts are not disputed. The material fact being the list of members of congregation of the first defendant conveyed in a letter of 10 January 2022, in which not all the names of the members of the second and third claimants were included. This fact is not denied, but further facts were supplied to the effect that the letter of 10 January 2022 was a response of the second, to the second and third defendants' letter dated 6 January 2022. Similarly, the claimant counsel in his written address simply submitted that this case simply calls for the interpretation of Section 41A to H of the third schedule to the Federal University of Technology Act, which has already been determined by this court in NICN AK 2018 and laid to rest. It must be pointed out that the submission of the claimant counsel is correct to the extent that whether or not the claimants are qualified to be members of the congregation of FUTA and the issue of definition of administrative staff was already settled in NICN/AK/46/2018. It is the case of the defendants as shown. It is the case of the defendants as shown in the account affidavit as follows: that although first claimant is a representative of the congregation at the management board of FUTA Secondary School, that fact alone does not assure attendance or participation in all meetings of congregation. That the letter of 10 January 2022, Claimants Exhibit D, was predicated upon a letter of Nasu and Sanu, second and third claimants, dated 6 January 2022, Defendants Exhibit PP2, which claimants omitted. That in Exhibit PP2, the second and third defendants requested for a list of the members of congregation for the purpose of a meeting of congregation scheduled for 13 January 2022. The list of members of congregation attached to the letter of 10 January 2022 Claimants Exhibit D is the list of persons, Sanu and Nasu, who were approved to attend the January 13 meeting of congregation. From the facts of this case and Exhibit D, which list includes all cadre of administrative staff from various departments, it cannot be said that the defendants excluded all members of the second and third claimants from membership of congregation. The defendants only excluded some names, whereas the name of the claimant had been included from 2019 to 2021. The claimants have not argued or shown that every person who is qualified to be a member of congregation has an unfettered right to the attendance of every meeting of the congregation in spite of Article 4.3 and 4. 4 sub 3 and 4 sub 4. Please, you are interfering.
Sorry. I'm taking judgment.
Please.
Sorry, my lord. I'm in the court.
Judgment is on. Please, off your mic. I find it as a matter of fact that the letter communicating the list of members of congregation, Exhibit D, was a response to a letter of demand from the second and third claimants, Exhibit PP2, which reads as follows. I read from the letter. I read the content of the letter. Request for the list of congregation membership. Fraternal greetings from our esteemed members and compliments of season to you, sir. We received a notice of special meeting of congregation scheduled to hold on Thursday, 13 January 2022. Rising from the rowdiness that greeted the last meeting of the congregation on the issue of membership, we write to request for the authentic list of members of congregation so as to enable us inform our members and give it enough publicity accordingly. It will be appreciated if we can have the list within 24 hours with effect from 1 p.m. today, Thursday, 6 January 2022. It was in response to the above letter, Exhibit PP2, that the letter of 10th January 2022, Exhibit D, was written, conveying the list of members of congregation among the second and third claimants. What is clear is that this demand from the second and third claimants was with respect to a notice of special meeting of congregation scheduled to hold on Thursday, 13 July 2022. So I agree with the learned circle of Defendants Counsel that Exhibit D was with respect to that meeting of the congregation scheduled for Thursday, 13 January 2022. What is also clear from Exhibit PP2 is that the second and third claimants recognize the powers of the Vice Chancellor, excuse me, with respect to list of congregation members, and this cannot be any other power besides the discretionary powers in Article 4, Paragraph 4 of the third schedule to the Federal Universities of Technology Act. So the second and third claimants by Exhibit PP2 activated the Vice Chancellor's discretionary powers as per Article 4, subparagraph 4 of the third schedule to the Federal Universities of Technology Act. This issue now is as canvassed by Learned Fakunle San, counsel for the defendants, which is whether in spite of their qualification to be members of the congregation of the first defendant, they can be precluded for the purpose of any particular meeting. This issue, as rarely submitted by Learned Ajayi Adeolo of counsel to the claimants, was settled by my Lord O.O. Oyewumi in NICN AK 46 2018 Exhibit A at pages 26 and 27, reproducing Article 4.3 and 4.4 of the third schedule, which is as follows. 4.3. The quorum of a congregation shall be 1/3 or whole member nearest to the third of the total number of membership of congregation, or 50, whichever is less. 4.4. A certificate signed by the Vice Chancellor specifying A, the total number of members of congregation for the purpose of any particular meeting or meetings of the congregation, or the names of persons who are members of congregation during a particular period, shall be a conclusive evidence of that number, or, as the case may be, of the names of those persons. My Lord then continued as follows, and I quote, "The significance of this is that at any particular meeting, the membership of the congregation for the purpose of attendance may be limited by the Vice Chancellor in the exercise of his discretion to ensure compliance with Article 4, Sub 3 of the third schedule to the Act. This does not in any way restrict the staff of the first and second claimants who are staff with a degree in the university and not on the Vice Chancellor list to lose their membership. It merely means that members of the congregation other than those whose names appear on the list, each signed or issued by the Vice Chancellor, having first acted in fairness and equity and equitably, cannot attend a particular meeting. Consequently, I find that members of the first and second claimants who are so qualified under Article 4.1h of the third schedule to the Act can still be members of the congregation, but may be denied right to attend or attendance by the exercise of the discretion of the Vice Chancellor. I find the above reasoning and conclusion unassailable, and I adopt them as mine in this judgment. In other words, a staff can be qualified to be and is a member of congregation, but the discretion of the Vice Chancellor can limit the number of members of congregation for the purpose of attendance of a particular meeting or meetings. I further find and hold that the list of congregation members as per Exhibit D was in response to the letter of the second and third claimants, Exhibit PP2, in respect of a meeting scheduled for Thursday, 13 January 2022, and Exhibit D is only applicable to that meeting of Thursday, 13 January 2022, and is properly so done in line with the discretionary power of the Vice Chancellor as contained in Article 4.4 of the third schedule of the Federal Universities of Technology Act. Going by Article 4 of the third schedule to the Act, there is no provision for a permanent list of members. Neither have the claimants shown that the list Exhibit D was a permanent list, nor have the defendants so contended. The claimants seem to aver that some members of the claimants were omitted because of the defendants interpreting administrative staff to mean administrative officers only. How or by what instrument was that interpretation by the defendant conveyed to the claimants have not been shown to the court. This allegation of such interpretation of administrative staff by the defendant is not proven. On the whole, and in view of the above findings, the two questions for determination are resolved against the claimants and in favor of the defendants. Accordingly, the case of the claimants failed, and it is failed in its entirety, and same is hereby dismissed for want of merit. Each party to bear its cost. This is the judgment of the court, and it is entered accordingly.
Let's go, please.
as a couple visit. We are very grateful, sir. The industry that has been shown in this matter. We thank you.
Let's check whether the defense counsel has now appeared.
Okay.
The claimant counsel has he now appeared? Is the claimant counsel now online?
I don't think there's any, my lord.
Okay.
My lord, we are very grateful, sir.
$29. All right, thank you very much.
Yes, sir.
We
We
shall
are grateful, man.
proceed to the next matter. AK-41 2021 between Shino Isaac Ibiemi and Legal Aid Council. Appearances?
May it please the Honorable Court.
Yes.
O.A. Owolabi. My lord, I appear with my learned friend T.O. Ojo for the claimant, who is also present on the Zoom hearing.
Yes, defense counsel.
Yeah, with due respect, your lordship.
Yes.
Oseni Agbogayeme. My lord Oseni spelled O-S-E-N-I.
Yes, it is the other name that is my problem.
Stop this.
Well,
A-G-B-O. A-G-B-O.
yes.
G-H-A-I.
Yes.
Y-E-M-E-H. Agbogayeme.
Thank you.
We humbly appear for the defendant, my lord. We are much obliged.
You and who? You and who?
I'm alone, my lord. I appear for the
I
defendant, my
heard
lord.
you saying we.
I'm sorry, my lord. I appear for the defendant, my lord.
The matter is for judgment.
Yes, my lord. We are ready, my lord.
Yes, my lord.
Yes, thank you.
having judgment.
Gentlemen,
Yes, my lord.
we don't have light here.
Okay, my lord.
I'm reading from my system and my battery is gone, almost gone. I don't know.
Yes, my lord.
What do we do? We don't have light to print. I'm reading from the system and the battery is gone. So we may need to stand down this matter. Let's find a solution.
As God pleases.
As God pleases.
Thank you very much.
We are much obliged.
Yes. Okay, gentlemen.
Yes, my lord.
We shall leave the meeting temporarily and you will be called to join. If the passcode changes, we will let you know. But the judgment will have to be today.
We are much obliged, my lord.
Thank you.
Most grateful, madam.